requested us to prepare heads on the issue of the re-examination on the automatic vehicle location. We have prepared the...
You call it what? The issue of what?
On the issue of the re-examination on automatic vehicle location.
You mean the issue which arose during the re-examination?
Yes.
Yeah, which was basically when you said you want to make an application to lead Sergeant Mahono on the, you call it AVL?
Yeah, on the AVLs.
Yeah. And this, the defense is opposing that.
Yes.
Okay, let's hear you then.
Scott, please, my lord. We have divided the subject matter in 5 headings. In the introduction, we give a bit of a background. Then we, on page 2, on page 3, we deal with the purpose of re-examination. Then on page 4, we deal with the nature of the evidence that the state seeks to re-examine the witness on. Then on page 6, we give an explanation as why the movement report was not presented when the evidence in chief was given by the witness.
Okay.
And lastly, we deal with the interest of justice. I'm not coming to page 1, paragraph 1.1.
Yes.
We mentioned that the crisp issue at this stage of the proceedings is whether the state can be allowed to re-examine a witness by introducing the records of the automated vehicle location, what is also referred to as the movement report, paragraph 1.2. We mentioned that insofar as may be argued that this is new evidence, the state makes a formal application to the court to be allowed to re-examine the Sergeant Mukhani on the AVL records. In paragraph 1.3, we mentioned that the defense put it to Sergeant Mukhani that on the 19th of June 2020, while he was transporting the accused in a Toyota Fortuner en route to Moroka police station, he took a detour and stopped at a place near a filling station, near a directional board to Alberton, where the accused was assaulted. They proceeded to a dumping area on the way to Alberton, where there were steel stairs and poles, where accused number 2 was further assaulted. That they thereafter proceeded to Chris Hani Baragwanath Hospital, where Lieutenant Colonel Rapadu was picked up. Thereafter, they proceeded to an empty space at Orlando, where there were disused ATMs, where accused number 2 was further assaulted. That Brigadier Gininda appeared with some documents, and the accused was forced to affix his thumbprint on them And thereafter, they proceeded to Moroka Police Station to complete the process, as the accused did not affix his thumbprint on some pages. Paragraph 1.4. We submit, my lord, that these allegations are so serious that they ought to be investigated, and if the AVL records can assist the court in the determination of these issues, that it is in the interest of justice that this evidence be allowed at this point in time. Paragraph 1.5, we explain, my lord, that AVL is a computer-based vehicle tracking system used to monitor the movement of vehicles in real time. It helps to determine and transmit the geographic location of a vehicle in real time. And we make the point, my lord, that as it were, it's an eye in the sky. Paragraph 1.6, we make the submission that the AVL records will therefore show if there was any deviation along the route to Moroka Police Station. And we, in paragraph 1.7, we mention that the AVL records are therefore a silent witness. In paragraph 1.8, we argue, my lord, that it will not be necessary to await that a witness from the trekking company should testify first, as such evidence is usually given in a form of a 212 statement. In other words, just a formal statement stating that a tracking device was installed in a particular vehicle which provides vehicle location information, and that witness gathered or retrieved information from their system, and would normally state that they attach the vehicle movement information for a particular period. And that's purely, my lord, to authenticate the movement report. And we argue here, my lord, that the Sergeant Mokhani can authenticate this information, as he was the driver of the vehicle in question and has testified as to the route that he followed, which is contained in the movement report, the AVL. We make the submission, my lord, that he can therefore validate the information provided in the AVL report as reliable. And we mentioned, my lord, that at this point in time, there's nothing that stops Sergeant Mokhani from commenting on the movement report that we intend to re-examine him on. And we make this point, my lord, that even if it were argued that that it is hearsay evidence at this point, we refer to Section 3 of the Hearsay Evidence Act, subsection 3 thereof, which provides that hearsay evidence may provisionally be admitted in terms of Section 1B if the court is informed that the person upon whose credibility the probative value of such evidence depends will himself testify at the proceedings, and provided that if a person does not later testify, then such evidence can be disregarded. And we argue here, my lord, that and we've also indicated to the defense that this witness statement will be handed up in due course. And in under point 2, we deal with the purpose of re-examination. And we quote Section 1661 of the Criminal Procedure Act 51 of 1977, which reads as follows. And the heading there is cross-examination and re-examination of witnesses. We mentioned that under point 1, an accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings, or any co-accused who testifies at criminal proceedings, or any witness called on behalf of such co-accused at criminal proceedings, and the prosecutor may cross-examine any witness, including an accused, called on behalf of the defense at criminal proceedings. And we put an emphasis on the following: and a witness called at such proceedings on behalf of the prosecution may be re-examined by the prosecutor on any matter raised during the cross-examination of that witness. And this is, my lord, the exercise that we're trying to embark upon. And a witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. Under point 2, we mentioned that re-examination is the right which may be exercised when cross-examination is complete, as in casu, by the party who called the witness. The purpose of cross-examination is to clear up any point or misunderstanding, to correct uncertainties or wrong impressions which flowed from cross-examination, or to supplement something which did not come out fully. And here we refer to Himstra Criminal Procedure, the 2023 version at pages 22 to 61, as may have occurred during cross-examination. Under paragraph 3, we mentioned that re-examination is a useful mechanism to place a full and fair version of the witness evidence before the court, and thereby to get to the truth. And we refer to the case of Ramolope. The citation appears there. And under paragraph 4, this is now the basis upon which the current application is premised. New matters can be canvassed only with the leave of the court, which may allow further cross-examination on the new evidence, hence the state's application. Under paragraph 5, we submit, therefore, that no prejudice will be suffered, as the defense will be allowed to further cross-examine Sergeant Mohani on the AVL records. Paragraph 6, we therefore request, with the leave of the court, to re-examine the witness, Sergeant Mohani, on the AVL evidence. And, my lord, we mentioned that the evidence will only be confined to the route traveled by Sergeant Mohani on the 19th of June, so there was a typing error, should be 19 June 2020, whilst transporting accused number 2 to Moroka Police Station and thereafter to Foslores Court. Under paragraph 3, with the heading Nature of Evidence Sought to Re-examine a Witness on, we've already made the point, my lord, under paragraph 3, that AVL is computer-based vehicle tracking system. We're not going to rehash it here. Under paragraph 3.2, the defense for accused number 1 and 2 objects to this re-examination on the basis that it's new evidence. And I suppose other counsel who might also raise objection. Under paragraph 3.3, we mentioned that that the state contends that it is not new evidence, that now should read not new evidence, as during cross-examination of Sergeant Mokhane, the defense put it to him that he was transporting accused number 2 in a Toyota Fortuner vehicle, and whilst en route to Moroka police station and eventually First Lawrence Court, he stopped near a filling station near a directional signboard to Alberton, and that they were joined by Constable Buthelezi and Mapumlo, who were driving a Nissan hardbody. That Constable Jonathan also joined them driving in his vehicle. That accused number 2, so the version goes, was then taken out of the Toyota Fortuner and put in the vehicle of Constable Jonathan. That accused number 2 was then placed in the right rear seat of Constable Jonathan's vehicle, and that the late Sergeant Mabena sat at the left rear seat and Constable Buthelezi stood at the right rear door next to the accused, and that Constable Jonathan pushed the driver's seat backwards towards the knees of the accused, accused number 2, and pressed the knees very hard. It was further put to him that the late Sergeant Mabena used a silver-colored Truett's plastic to suffocate the accused, whilst Constable Buthelezi was blocking accused number 2 from leaving the vehicle. Paragraph 3.4. It was put to Sergeant Mokhane that from that place they proceeded with accused number 2 to a dumping area on the way to Alberton, and all the cars then stopped at that particular place. That there were steel chairs there with steel poles, that the hands of accused number 2 were handcuffed at his back, and were then, when they reached that place, they were taken off, and accused number 2's one hand was then handcuffed to a steel pole, and his jacket was then taken off. It was then put to the witnesses that the assault continued, and that accused number 2 was poured with water on the front part of his body. That Brigadier Gininda arrived in a white BMW with female Sergeant Mohola and another person in braces. Accused number 2 was then electrocuted by Sergeant Mabena. Constables Buthelezi and Jonathan taking turns. That when the plastic was removed from the face of accused number 2, he was bleeding from his nose. It was put to Sergeant Mokhane that he did not participate in the assault at the garage or the steel place, but that he moved away when accused number 2 was assaulted, and came back and said, and we quote Yekelan Diman, with close quotation, paragraph 3.5. It was put to the witnesses that there was then a meeting, and they drove to Soweto. That Sergeant Mokhane, accused number 2, and Sergeant Mabena drove into the premises of Chris Hani Baragwanath Hospital, where they met Lieutenant Colonel Rapadu. That Lieutenant Colonel Rapadu was with his wife and a child, and he gave his car keys to his wife. That they then drove with Lieutenant Colonel Rapadu to Orlando and stopped at an empty area where there were disused auto-teller machines. The cars were then parked, and accused number 2 was taken out of the Toyota Fortuner, and the assault continued. Brigadier Gininda then arrived with Sergeant Mohola and opened the boot of the BMW and sat on the edge. he took out certain documents and gave them to Colonel Rapadu, and accused number 2 was forced to sign those documents by affixing his thumbprint, and that from the 16th of June 2020, the accused was not 2020. The accused number 2 was not in the right state of mind because of the assault. Paragraph 3.6. It was put to Sergeant Mukhani that there were pages on which the thumbprint of the accused were not affixed. Hence, they proceeded to Moroka Police Station to complete the process. As already intimated, my lord, we make the submission that these allegations are so serious that they need to be investigated, and if the AVL records can assist in the determination of these issues, it is then in the interest of justice that the evidence on AVL be presented to determine if these serious allegations are true or not. And here, my lord, we're referring to the re-examination. The Sergeant Mukhani be re-examined on those AVL records. And under paragraph 4, with the heading explanation as to why the evidence was not led in evidence in chief, paragraph 4.1, we mentioned that the AVL records were only received on Friday, 3 November 2023 at 9:47, after the evidence in chief of Sergeant Mukhani had already been concluded. And we attached the email from Brigadier Gininda in this regard. And we mentioned under paragraph 4.2 that the AVL records were immediately disclosed to the defense when they came to hand. Paragraph 5. Under the heading, the interest of justice. Paragraph 5.1, we respectfully submit that it is in the interest of justice to allow this evidence to determine if the proposition put to Sergeant Mukhani that he took a detour and stopped at 3 places to allow the accused to be assaulted is true or not. Then, my lord, we refer to the case of Hepworth that has been traversed in these proceedings. 1928 AD 265 at 277, where the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other, and that the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We also refer to the case of State versus Sheikh and others. We give the quotation there, where the court held as follows, and we quote, "The applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. We also refer to the multi-choice case versus the National Prosecuting Authority and another. We give the citation there. Even if this case dealt with the right of the media to access the proceedings, the comments that were made by the Supreme Court of Appeal are opposite in this matter. And we give a quotation there in paragraphs 13 to 17. Our Constitutional Court has been vocal regarding the protection of the rights to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And in this regard, the Constitutional Court referred to the case of State versus Zukuza and others, where the court confirmed that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And we close the quotation. And we also refer to the case of Dlamini, Dlada, and others, Joubert versus Kitekat. We give the citation there. This case was given in the context of bail application. However, the remarks by Judge Krichler are opposite, wherein he describes what is meant by the phrase interest of justice, and he said the following, we quote, this is a useful term denoting in broad and evocative language a value judgment of what would be fair and just to all concerned. And we close the quotation. We therefore submit, my Lord, with respect, that the state be allowed to re-examine Sergeant Mukhani on the AVL. I mentioned on Friday that the state may as well lead the evidence through other witnesses, but the fact of the matter is that Sergeant Mukhani will then have to come back to then give his comment on such evidence. We submit that the balance of convenience at this stage and the interest of justice, my Lord, will be served if Sergeant Mukhani is allowed to be re-examined on the vehicle movement report. Okay. These are our submissions, my Lord.